the courts are giving rights outcomes that the federal Liberals like, and they're giving rights outcomes that the provinces don't like, that different provincial center-right governments who have different ideological kind of perspectives see as invading their provincial jurisdiction. So the fight was partly jurisdictional too. It wasn't just about the substance of the rights questions. And now we see that in spades. It's like our theory couldn't be proved better by the federal government directly arguing to set limits on Section 33, right? I mean, the Section 33 empowers the federal government too. Why do they want to limit their own power? Well, it's because they see the court as an ally imposing national rights standards when the provinces get out of line and disagree with the rights outcomes that the federal government prefers.
Hello and welcome to Inside Policy Talks, the podcast of the Macdonald-Laurier Institute. I'm Peter Copeland, Deputy Director of Domestic Policy here at MLI. Today we are tackling a live wire in Canadian constitutional law, the notwithstanding clause, Section 33, the Charter. A single clause meant to preserve democratic self-government may now decide the balance of power between courts and legislatures. Since its adoption in 1982, courts have played the more dominant role in shaping the charter landscape, but Section 33 was the political safety valve, the one that sealed the deal to pass the charter itself. It lets elected legislatures shield laws from the court's interpretation of select charter rights for 5 years, subject to voters thereafter. But the federal government's recent intervention on a Supreme Court case about Quebec's secularism law, Bill 21, threatens to upend that bargain. I care about this because the law in Canada is made by the legislatures, who are the elected representative of Canadians, and then are upheld by the courts. We have a constitutional order that enshrines a rule of law and which is both free and democratic, where rights are real and elections still matter. Our guest today to discuss this is Professor Geof Sigalet. Geoff is a political scientist, MLI Senior Fellow, and a leading voice on constitutionalism, the rule of law, and parliamentary democracy. He writes with great clarity about judicial review, separation of powers, and how Section 33 fits our legal and common law traditions. He's also contributed to MLI's work on rebalancing courts and legislatures. Geoff, great to have you here.
Thank you so much for having me, Peter.
You've been busy lately, I think. But let's start simple here. What is a notwithstanding clause in just a minute or so? What does it do? What doesn't it do?
The most simple level, it's a part of the Constitution, part of the Charter of Rights and Freedoms that allows the federal parliament or the provincial legislatures to enact laws that operate notwithstanding what courts have said about different provisions of the Charter. It doesn't apply to all of the Charter rights, though. It doesn't apply, for example, to Section 3 democratic rights or Section 6 mobility rights, but it does apply to the fundamental freedoms we find in Section 2, so freedom of expression, freedom of religion. It applies to all of the rights we assume, most of the rights we associate with criminal justice, and due process, so Section 7 to 15, including Section 15 equality rights also. It has a long controversial history, and it is one of those parts of the Constitution that gets talked about a lot once it's used. And it was part of the Charter bargain, and we can talk a bit more about that. It was something the provinces actually insisted on very forcefully in the negotiations that led to the enactment of the Charter in 1982.
That's great, Geoff. Yeah, that's where I want to go next. Why was it included in 1982? Some pressure by the provinces you alluded to. How did it make it in there, and why?
Well, there's different stories depending on different sources. Because remember, there's all of the premiers are negotiating together. They're not all completely on side about everything, and different premiers have different priorities about different things. There's also different stages in the negotiations that lead to the 1982 enactment. But the simplest, I'll get into the detail a little bit more in a minute, but the most simple answer to your question is that the that two premiers, Peter Lougheed, the progressive conservative premier of Alberta, and Alan Blakeney, the NDP premier of Saskatchewan, both insisted and advocated for something like the notwithstanding clause at a crucial stage in the negotiations that led to the charter as a kind of compromise where they were willing to accept a charter of rights and freedoms, but that it must include something where the provinces were able to enact laws notwithstanding what courts might say about different controversial charter rights. And they both came at that from different perspectives with different kinds of concerns about the ability of courts to invalidate provincial laws under the charter. But they had an overlapping concern with judicial activism, with the ability of courts to interfere with the policymaking powers of the provincial parliaments in ways, including in ways that might favor the federal government, given that the appellate courts in Canada are federally appointed. And so that's the simplest version. The little more complicated thing that people often don't know about that I write about in my research that's kind of fun is that there's another part of the charter that was meant to help reinforce provincial power and actually legislative power, because remember the notwithstanding clause at the end also is available to the federal government. Another part of the charter that enables legislative power and is meant to include recognition of legislatures' role in understanding charter rights was Section 1. Section 1 allows for reasonable limits that can be demonstrably justified in a free and democratic society. The early version of Section 1 actually included a reference to parliamentary power and in a parliamentary system of government. And that was actually the version that was submitted to the joint House and Senate committee that reviewed the charter proposals and heard people who had concerns about it and different ideas about how it should be redrafted. And a lot of the people in that committee didn't like that provision and the way it was worded because it seemed to clearly signal a large role for legislatures in determining charter rights. And they thought it would make the charter less of a powerful document, less of a judicially enabling document in terms of enabling judges to really forcefully advocate and strike down laws under the charter, because the document would recognize a parliamentary system of government, potentially continuing to recognize the existence of parliamentary supremacy, right? The ability of parliaments to have the last word about these rights questions. And so there was lots of advocates for the charter from different kinds of advocacy groups that attacked that wording of Section 1. And then Jean Chrétien, the Minister of Justice, redrafted that version of the charter and took parliamentary system of government out. But then the feds had a problem. Trudeau and Chrétien had a problem because that was put there to kind of help entice the provinces and make the charter more appetizing to them. So in the next round of negotiations, the provinces actually responded saying, okay, no charter. We'll patriate the Constitution just with an amendment formula. And then the Supreme Court kind of broke the impasse between a charter without even the version of the Section 1 limitations clause the provinces wanted, and a patriation formula, amending formula with no charter. The courts came out and famously said that Trudeau could legally unilaterally patriate the Constitution, but he needed substantial consent from the provinces. That forced both parties back to the bargaining table. And then Section 33 came in as, okay, well, you've watered down Section 1, so it doesn't refer to parliamentary system of government the way we want. Now we want Section 33. We want something that looks like a notwithstanding clause. Actually, in those parliamentary hearings about Section 1, where the people are complaining about Section 1 referencing parliamentary system of government, Alan Blakeney referred in those hearings to Section 1 as a kind of notwithstanding clause in advance, which he likes. So once they take that advanced notwithstanding clause out of the charter or they water it down, then Alan Blakeney and Peter Lougheed come back to the table and say, okay, if we're going to have a charter, it needs something like a notwithstanding clause. And then there's back and forth about what the notwithstanding clause looks like. Trudeau insists that after 5 years, the laws enacted under the notwithstanding clause expire and need to be reenacted. The provinces get their way in that there's no limit on the reenactment of every 5 years. They can reenact the law as many times as they want. In some cases, there have been repeated enactments of notwithstanding clause provisions. And Peter Lougheed and Blakeney, despite being ideologically different, they both have this vision that judicial activism can be a problem under a Charter of Rights and Freedoms. And they went and got opponents of the charter, people who were even more opposed to a charter than they were, like Sterling Lyon. And they said, well, with the Section 33 notwithstanding clause, it becomes more of an acceptable compromise. And that's how we got where we are. That's how we get the final drafting of the wording of Section 33. But that is not, it's not commonly known enough, even among law professors. It's sort of evident by recent discussions that Section 1 actually has a relationship to Section 33 in the drafting this way.
Right. Well, that was a fascinating history, and just seeing all of the back and forth before where it landed. I think what may not be evident to everyone listening is what's at stake between who holds a final say from an interpretive perspective about the meaning of the law. Can you elaborate on that? Like, what's in play here?
There's a lot at stake. There's a lot of different considerations, right? It's a complicated question of on fundamental rights questions, which institutions do you fundamentally allow to make decisions about those questions, and how? And there's systems and there's different institutional choices that countries can make. Many modern liberal democracies do not have constitutional judicial review. They do not have bills of rights that are enacted as part of a fundamental constitution that is enforced by courts. So the United Kingdom, Australia does not have a Bill of Rights, a constitutional Bill of Rights. It does have constitutional federalism. New Zealand does not have a constitutional Bill of Rights. It does. New Zealand and the United Kingdom both have statutory bills of rights, but those could be repealed by the legislatures, and they don't allow courts to strike down laws under their rights. They're just interpretive bills of rights. Many other countries in the world, Scandinavian countries famously have a weak form of judicial review. So there's different options you can take. And on the opposite end of the United Kingdom and New Zealand, or the opposite end of New Zealand, let's say, is like the most clear parliamentary supremacy country left in the Commonwealth. You have the United States, which has for a long time had constitutionally entrenched rights that are enforced by the judiciary. That really becomes the full American model we know today really develops more in the civil rights era. But there's constitutional judicial review of a kind enforcing bills of rights throughout American history. Mm-hmm. And so what we get, if you want to understand the sort of big picture, what we get with the Charter in 1982 is a constitutional document that's it's not American. It's not saying that courts have the last word about these rights questions that are constitutionally entrenched. And it's not pure parliamentary supremacy anymore, in the sense that Parliament has the last word about everything, is the kind of highest court in the land, the way that New Zealand is. Instead, we have something in between where we have clearly increased the role for courts in protecting rights in our model of constitutionalism. But we also have preserved a strong role for legislatures. And one of the strongest signals, clear constitutional signals, that the legislatures play a major role in understanding rights and determining rights and deciding rights, is Section 33, which ultimately preserves a final word. Like, the legislatures can enact laws notwithstanding what these provisions mean, what are interpreted to mean by the courts, for 5-year periods without any limitation on reenactment. That's the way the text is drafted. That was part of the deal that we got. And that is part of our system, kind of being an in-between American, sort of classically Canadian, in between America and in between the United Kingdom, in between the mother country and in between the Yankees down south that influence us more and more over the 20th century and now this century.
Yeah, and I think it's one of our great strengths, because there are merits to both, the courts as an institution having a degree of power, and Parliament. But of course, as you note, the clause is its proper functioning is crucial to striking that balance. One brief aside I find interesting in some of the discussion on this is that you sometimes get the impression that charters or constitutions or even the law itself is a very straightforward and easy kind of to interpret, right? So if you're restricting a right, so to speak, or you're suggesting that the court's version of or their accumulated interpretation of the meaning of some right does not apply to a piece of legislation that you're enacting, if you take that position, it's not evident, or I should say, sorry, many people assume that it's very straightforward how, say, like the right to healthcare or some equality right applies. But of course, it is in fact very vague and unspecified. And even in Canada, where we have this history of living tree interpretation that derived from a court case in the early 20th century. Um, it suggests to me anyway the need for like a clear balance, because if you have the courts having too much interpretive power, or the legislatures, it's in fact not that clear cut, the letter of the law in many cases, what it entails. And so there's a need to have a balanced way of adjudicating between them. Do you have any thoughts on that?
I have a lot of thoughts on that. Where to begin? Um, I think that's right. That many of the charter rights, many constitutional provisions are very abstract. But rights are particularly abstract in many cases. So we have the freedom of religion, right? What does that mean exactly? Or freedom of expression. What does that mean? Does it mean you can't reveal state secrets and do the freedom of expression to say what you want, or say say things that are highly secretive, confidential matters of state that endanger Canadian soldiers and Canadian interests? I don't like. There's always lots of questions about how these abstract declarations of rights work out in the particular circumstances and particular kinds of concerns in relationship to different kinds of very messy policy questions often. And so there's absolutely some truth that sometimes constitutional rights are a little clear. So, for example, the Section 93 rights to denominational schools where there's minorities, a historical religious minority, those don't apply. I mean, Section 93 doesn't apply to all the provinces. Even the provinces it originally applied to have amended it to not apply to them anymore. But where it does apply, it's actually a pretty clear right. It's a clear right that says that where there's a historical denominational minority, so where Protestants are a minority in dominated Catholic areas, or where Catholics are a denominational minority in dominant Protestant areas, that they have the constitutional right to publicly funded schooling. That's actually a very clear right. That's really related to, one of the reasons it's clear is because it was related to a very clear compromise about what specifically needed to be protected in the Canadian constitutional Canadian constitutional order as a matter of early Confederation history,
Mm-hmm.
where if you were Catholic, you were probably French. If you're English, you're probably Protestant. And we knew that there was a lot of prejudice and cultural conflict tied up between those groups. And we knew that education was an important way of preserving those difference in cultural things, right? So those were more specific
Mm-hmm.
and a little easier for courts to settle in a way that looked more law-like. When it comes to more abstract declarations like freedom of expression, it becomes a bit more difficult to say, what exactly does that entail in some of these messy situations?
Mm-hmm.
And I think that's part of it. Can I say one thing? I think in terms of balancing the legislature and the courts, one thing I see, and the law professors are guilty of it, and the general public, I mean, commentators are definitely guilty of it, is we see this assumption that there's a tyrannical majority out there that controls the legislature. And that tyrannical majority needs to be stopped by a heroic kind of counter-majoritarian court that doesn't represent, that's independent. And what I think is interesting is that many political scientists would say that that understanding and conception of what's going on institutionally between the relationship between the institutions is a bit of a mischaracterization of some of the dangers involved in letting courts into these kinds of conversations. One of the dangers is not just that the court might overturn the enactments of a legitimate democratic majority. One of the dangers is that the court will be used as a tool by a democratic majority, even to enact things and get policy outcomes that you couldn't get through the majority process. That the majority, which is actually not a clear majority of everyone's views about political society, but rather a party elected on specific platform promises, specific ideas about how things should go. That itself is often a coalition of different interest groups that are different factions that have come together. That sometimes those factions will make deals where they want or be interested in having their policies pushed through the courts in ways that they couldn't get away with in the democratic process, the main process. So one problem here is that the courts coming in can be, and into some of these policy areas where things are very vague, can be a way for political actors in the democratic arena to escape accountability and responsibility for some of the policy preferences they have that they might not be able to get away with if they were forced to squarely enact them in the democratic process.
Mm-hmm. Absolutely. Yeah. I think people have, unnuanced perspectives about the rationality and the um, decision making criteria that courts versus legislatures employ. Of course, the body of law and the practice of judicial interpretation should be and is, I think, a little more constrained. Of course, in the democratic process appropriately, but it is also subject to political influence and as you say, good example of yes, the judicialization of politics, courts increasingly taking on political adjudication functions in Canada, perhaps due to its the institutional legitimacy it still commands, but is waning a bit in recent years. We'll come back to some of these things, Geoff, but now to the issue at hand that has got the notwithstanding clause back at the top of the news cycle. You've laid out well the compromise that was struck, and a balance really to ensure that courts' power was balanced with the legislature through the adoption of the charter. Why does the clause remain so politically contested? We've seen it in the kind of news firestorm that has emerged following the federal government's intervention on an English Montreal School Board case. Help us understand the dynamics in play in this case and then the broader political landscape.
Okay, so I should just talk about the case first, then probably, and then we'll just talk about how we got here. So the case is the English Montreal School Board case, but it's also referred to as Hack because the lower cases had Hack as the primary litigant. Well, the trial court case had Hack, and what this case is about Quebec's secularism legislation. So it's called often referred to bill as Bill 21. It's no longer a bill; it's a law. It's Loi 21. Not Bill 21 anymore, but we still call it that for some reason. And what that law does is it prohibits certain public servants, like police officers and teachers, from wearing religious symbols, prominent religious symbols. You can have a private cross no one can see around your neck, or a private moon and crescent, or something like that. Crescent moon, I don't know, or a private Sikhism symbol. Like, that's fine, I think, under this law. But you cannot have a prominent religious symbol. So you can't wear a kippah, you can't wear a hijab, and you can't wear like a big obvious honking cross in the front. And if you are working in certain public services, not all of them. And this is related to the particular history of Quebec with the Quiet Revolution and its own internal politics probably also about immigration. And Quebec's own view of itself and its changing philosophy about how to deal with religion in the public sphere. These issues are obviously much more hot button if you click into the francophone world of Quebec political discourse. And essentially, the law would have been quite a good target to challenge under the Charter's protection for freedom of religion, because it's restricting the ability of individuals to exercise their freedom of religion by wearing these different religious symbols, right? So what Quebec did is it used the notwithstanding clause to protect its law. And then a number of litigants, and then that clearly seemed to take the ability to challenge that law under freedom of religion off the table. And then a number of litigants came up, and a couple of law professors came up with some clever arguments about how to get around the use of Section 33, both using other parts of the Charter to try to say that this violates those other parts, other constitutional provisions even. There's some other creative arguments that don't even have to do with the notwithstanding clause necessarily, but are also suspicious in my view. And then there's also arguments saying that, and new arguments saying that the notwithstanding clause does not protect you from the courts having a say about the rights it's implicating. And there's different versions of the argument, but one version of the argument at least says, the prominent one that emerged also in the Government of Canada's factum about this case now at the Supreme Court, was that courts could still have a say about these rights and make declarations that the law violates rights, even if that declaration doesn't make the law invalid and inoperative.
Mm-hmm.
Now, this gets into all kinds of really detailed legal debates, and I don't want to get too detailed here too quickly. So basically, that case now has found its way up to the Supreme Court of Canada. At the same time, a law enacting using the notwithstanding clause was used in Saskatchewan to protect Saskatchewan's pronoun policy. Um, Basically, the Saskatchewan Court of Appeal held similarly to those arguments made in the Quebec case, that you could make declarations about laws that invoke Section 33, even if you couldn't invalidate them. Now, actually, the Quebec Court of Appeal said no, said you can't. They rejected those kinds of arguments. They said, no, you can't make declarations about Section 33. They also rejected most of the other arguments, saying that you can get around and limit Section 33 with other parts of the Constitution. And the Saskatchewan court didn't buy those arguments, but we now have a split between the two courts of appeal, where one court of appeal has said that once Section 33 is used, there's no commenting and making declarations about it. It's the law until it expires. Then you can maybe have a say, and the courts can litigants can challenge it again based on the charter rights it applies to that now apply to it again after the expiration. The Saskatchewan Court of Appeal is something different. So the court may actually take the Saskatchewan case and hear at the same time. Saskatchewan and the litigants in the Saskatchewan case both want that. But we're basically going to get a ruling on these controversial arguments about how Section 33 relates to the judicial power, whether there's a judicial power to declare laws to violate charter rights, even if the law continues on operating. And then there's also one of the reasons you'll see this case so much in the news isn't just because of Bill 21 that already made it a newsworthy thing, because the Bloc Québécois, the Parti Québécois, all of the political parties in Quebec, the Parti Québécois and the Coalition Avenue de Quebec, they're all up in arms about the courts sticking their noses into this business, into the National Assembly's business of invoking these laws with Section 33. That would already be newsworthy already. But the last week, or was it the week before, I forget, the federal Attorney General sent his factum, his argument about the Bill 21 case in, and he didn't just make the argument that they can make declarations, that the court should make declarations about laws that validly use Section 33. He also argued that they should be able to set limits on repeated uses of Section 33. When you repeatedly use Section 33, you're de facto amending the Constitution by rendering the right inoperable. And to give the most charitable version of this argument, that the 5-year expiration signals that this is always supposed to be a temporary thing, so you can't permanently amend the right that is targeting, right? And that obviously caused a firestorm, because if the courts went for that, it would absolutely be a essential de facto constitutional amendment in the eyes of many of the provinces, who have all filed factums arguing that there's certainly not that power. And so some of the provinces have said there might be a declaratory power, but there's also many of the provinces very forcefully arguing that there's not a declaratory power at all. So Alberta, Ontario, Saskatchewan, and Quebec have all very forcefully argued there's no declaratory power. BC's kind of confused, it's sort of in the middle. I'm not sure what the AGBC was thinking with her factum, but we can get into that later. So that's where we're at. We have this big case that might even set limits on Section 33, in which case there will be an absolute, there's a major federalism dimension to all of this, right?
Yeah.
There is going to be a potential constitutional crisis if the court went for that argument. Now, I don't think the court is going to go for the set substantive limits on the charter. I do think it's possible the court goes down the middle and makes the case for declarations about laws that validly enact Section 33. But even that will be extremely controversial. It'll be still the court sticking its nose into this part of the Constitution that's meant to limit their power, right?
Yeah. Okay, so let's take them in turn. First, the question about limiting the subsequent reenactments of the notwithstanding clause. This idea they would maybe introduce some test, some sort of irreparable impairment of the right. is I think referred to in their factum, and you're seeing this would be a kind of de facto amendment of the Constitution were the court to rule that way. Um, can I get your comment? Was it in fact the case, like either explicitly or implicitly, that the notwithstanding clauses continued reintroduction would be like it should not be used in perpetuity? That would kind of, or it was not specified. Like, is there something to that kind of argument, or not really?
I've written a lot about the history of the framing, and I've never encountered anything, even from opponents, suggesting that this was the case. You can even tell, and so sometimes people argue against preemptive uses too, but there's
Mm.
no evidence that it was not meant to be used preemptively. In fact, we have clear evidence that it was allowed to be used preemptively, both textually and
Yeah.
because some of the framers. So Peter Lougheed got a little softer about the notwithstanding clause later in his career, and at one point he suggested, "Oh, we maybe should amend it so it couldn't be used preemptively." But in that doing so, he very clearly signaled it was always supposed to be used, able to be used preemptively. We just maybe I'm reconsidering my ideas about that.
Yeah. Well, no, exactly. Yeah. So it was not. I mean, there was nothing out there that, in fact, this is
No,
a viable limitation on its
no.
use.
The premiers accepted the 5-year expiry at Trudeau's insistence, and he was in the process. He was trying to horse trade for more limits in different ways. But I mean, ultimately, I think the process actually made the feds think that maybe they should have this power too. So they accepted it kind of as a safety valve at the federal level. You often hear, so you said safety valve in the introduction to this talk, and safety valve, the use idea of Section 30 is some kind of emergencies only safety valve. That's not in Lougheed and Blakeney's understanding of this, really. But there's a little bit of some commentary like that in Lougheed later on. Like I said, Blakeney didn't talk about that at all. Blakeney thought it could be used for all kinds of things, um, and if the courts got out of line enough, it would be used all the time. There's nothing in Blakeney saying that it could be restricted to these emergency situations only. But there is talk about safety valves and stuff from Jean Chrétien and Pierre Trudeau. In particular, Jean Chrétien, when he introduces the charter to Parliament, right, to pass a resolution saying that asking the Constitution to be amended, he says this is going to be a safety valve. But he was opposing Section 33 in the negotiations, right? So we take up his language. I mean, and it's interesting that they accepted a thing at the federal level that they were opposing. And so you can say, oh, that may be actually somewhat decent evidence about how he understood the federal use of the notwithstanding clause to go. But it doesn't change the fact that he accepted the wording of an instrument that applies to both levels of legislatures. Um, that has no limit on reenactments, no limits on preemptive uses, and nothing in it at all wording about it needing to be used in safety and as a safety valve in emergencies only. Right? That was just kind of an empirical expectation. Like we'll probably use it in emergency situations.
Right. Well, no, this is good that you again give us the history and terms like safety valve versus opportunity for the legislatures to contribute to the joint interpretation of the application of laws. These things, I suppose, are both not in the straightforward text, but are different opinions about the value, I suppose, of the clause. But that was illustrative. I think it to my mind anyway, shows that again, if we're looking at the rights in question and how vague they are, in fact, like you can't look at the text of it and simply right there understand exactly all of its applications and how that squares with other rights and laws that it might come into conflict with. And so it's natural that both the courts and the legislatures, through their various interpretive actions, would signal things about how, for example, freedom of religion and other rights are to be interpreted.
Right.
I want to shift to the other question here. So that's the idea of subsequent enactment. But what about the other question in the federal factum?
Oh, the declarations.
The declarations, yeah.
Yeah, I mean, I have a lot to say about this. There's sort of one basic point, though, I think, to get across. So we get into the technical details of the law. I want to say one thing, which is that it's very, very clever arguments on the part of at least one law professor, Professor Gregoire Weber's argument about he focused in on the language of Section 33.2, which says the law shall protect every law that invokes the notwithstanding clause will have the operation as will operate as it would but for the provision of the charter. And what he tried to say is and argue is that, well, that means it only protects the operation of the law, not its consistency with the Constitution. So it's an exception to the general rule we have that laws that are inconsistent with the Constitution are invalid and null and void and inoperative. And so he said, look, it protects the operation of an unconstitutional law. And so whether or not the law is consistent with the charter or not, the courts can come in and have a say and tell us more about that, inject that into the democratic process and have a kind of commentary about it. But that is it only protects the operation. That they can't invalidate the law, right? And Dean Leckie and Eric Mendelsohn, who initially wrote with Weber in an initial piece, they kind of split. They said, "Oh, we don't like the operation argument. We like this other argument, saying that well, the structure of the charter means that there needs to be an informed populace when it's used. So the courts need to fulfill that function. But that's not really rooted in the text at all. They kind of stopped arguing about the text and started arguing about like the broader structure of the Constitution. I mean, to be fair, they tried to hook it onto different textual provisions, but it's not a direct textual argument. And so you have these two clever arguments, in particular, focusing on the operation text. I think it fails textually. I think when you look at the text of Section 33.2, it says it'll have the operation it would have, but for the provision, which means that the law operates as if the provision didn't exist and apply to it. And the beauty of that is it's kind of an exact legal framing for saying that this is not something you should be looking to the consistency of this with the charter. This law is now in the political process. And the nice part about that is it means that it tells the court to imagine the law operates as it would but for the provision, even though we know that there's still the rest of the charter there that does exist for you to apply it to and think about. It's just that it's for the Canadian people and politicians to figure that out now, not the courts. So it's very directly textually limiting judicial review and limiting the ability of courts to have a say about it. And I think that's a clear argument. And so the Alberta Attorney General has made that argument his factum. The Attorney General of Ontario did a fantastic job in their factum, and they picked up my argument about that. But let's just step back. We were getting in a little bit into the weeds of black letter law, which I have fun doing, and I think that both of those authors are honorable but mistaken in their view of how Section 33 works about these declarations. I just want to step back and just say, though, think about the basic historical purpose of Section 33. It's obviously meant to limit the ability of courts and their power over these kinds of rights questions. It seems to go directly against the purpose of the provision of the charter to then say that they now get to come back into the conversation and talk about these rights questions about when a provision has been used that's meant to limit their power. That doesn't make sense to me. And insofar as our court's basic philosophy of constitutional interpretation is purposivism. It looks at the purpose, including the historical purpose of different kinds of parts of the Constitution. This idea of commenting on laws that invoke Section 33 just seems to go directly against that purpose to me. And I haven't heard a good explanation of how it doesn't. There's a kind of attempt by Leckie and Mendelsohn who sort of base their view on something like this, that, well, we need the courts to be saying these things, but we've already heard from the courts often about these things. And in most cases, we know a lot about what the courts will say or what they have said or what they will say. And it's the legislature's turn. It's not the court's turn.
Well, I suppose if you have a philosophy of judicial interpretation that is not as constrained by the text or official documents in construing, the meaning of the text or to the accumulation of our common law tradition and a kind of living tree approach to judicial interpretation, then one could construe the purpose a little more broadly, perhaps to what maybe the Prime Minister or the Attorney General at the time were thinking, and that I think says something about the state of our current judicial landscape here and what's going
That's
on.
true. However, notice that Weber's view is very textual. It's actually overly textual in that it focuses on one word and not the overall phraseology of the full text in that clause. And that's what I like about that argument, is that at least we're arguing about the text and what it means. I just think it's mistaken. If the and I like the grounds of argument that we're arguing about the text and its purpose and looking at history. But what I don't like is this abstract speculating about the court's role philosophically, like you're saying, which is more what Lecky Mendelsohn view ends up indulging in.
Right. Yeah, which is where the abstraction creeps in. So, Geoff, you were speculating that a likely outcome could be the court, accepting the declarations arguments, but rejecting the repeated application. I'm not going to hold you to that or anything, but I wonder if that might be consequential nonetheless for the reasons that you've already enumerated. But there was another recent decision, the Power decision, which perhaps you could explain, but briefly allows for damages to be awarded when laws are found to be in contravention of the charter, but left standing, as you say, which seems like a likely scenario if the courts were to rule this way.
So the relationship between power and this case, I think your concern is that courts will issue a remedy of a declaration and then also decide to give people money or issue orders about what different state actors have to do in relationship to the insofar as they find a finding and declare a law to be violating rights, right? Even though if they let the law keep operating. Now, I don't think the court's going to go for that. I do think that if you take the declaration power seriously, it may allow for some creative ability to do this. I think that that's actually, if you accept that courts should be reviewing these things and saying things about them, then there should be some kind of there's a case to be made that it should be offering remedies too. There's also a case to be made that Weber tries to make the case that, well, the declaration just is the remedy and it's the only one textually allowed. But again, his view is very textually concentrated. With the Lex textually concentrated view, and even his view also is the problem that Section 24 of the Charter doesn't allow, Section 33 doesn't apply to Section 24, which is a remedies provision for damages under there's charter violations, breaches, right? Now, our courts have interpreted that a particular way, so I won't get into all that, but there's a possibility at least that Section 24 remedies should follow if there's these declarations, even if they're not invalidating the law, right? Even if they're not making the law inoperable.
Mm-hmm.
And I think that's a possibility. It's certainly more logically in play once you buy these things. I just think that politically, the judicial politics of it is such that I don't think the courts are going to want to go down that route. I don't think they're going to want to go down that route fully, even if they buy the declaratory power. But I've been wrong before, and so we'll see. So I don't want to put all my chips in the pile necessarily, but I'll put a few chips in the pile to say that I don't think the courts are going to go for remedies like that. I also don't think the courts are going to buy Attorney General Fraser's rather wild idea that they shouldn't, that what the Constitution says, that there's no limit, the Constitution says no limits on reenactment, that they should put limits on that. I think that will be absolutely wild to many of the Supreme Court justices themselves. They'll read it the same way I am. I think that the declaratory power may appeal to a subset of them, and it may become something that some of them agree about. Despite I think at least two of the justices will dissent from that too. I think there's also the possibility we get a majority that dissents from both. And there are 3 Quebec justices on the court, and this issue is more hot button in Quebec. It's not necessarily that they're going to be cowed by public opinion in Quebec or anything like that. It's that they also understand that the Quebec justices will tend to understand these issues in a way that's a little perhaps more attentive to the federalism dimensions at stake here. I also think it's possible, it's at least possible that one of the Western justices may also pay attention to that. I hope so. I think we'll see. It's definitely a possibility that we get some kind of decision embracing declarations. I don't think we may get a dissent, embracing the more substantive view that there could be the repeated, let's say, the factum of the Attorney General of Canada's repeated uses argument. But I don't think that's going to be the majority decision, thankfully.
Mm-hmm.
I think that even if we do get the declarations decision, a decision saying there can be declarations about Section 33 enactments, there's still going to be public falling out about that.
Yeah, certainly a lot at stake in any scenario. But you've got your chips out there on the table, Geoff. We'll have to revisit this again once the court comes down with its opinion. I want to return to the history a little bit before we conclude. So, the court has reviewed Section 33, I believe, on one other major occasion in Ford versus Quebec. What did the court say about it at that time, and has it subsequently said anything material about Section 33?
There haven't been very many cases about Section 33. Certainly no big landmark cases with holdings about
Mm-hmm.
it since Ford. But what happened in Ford is the court said is the Parti Québécois when the charter was enacted, Quebec didn't sign the Constitution, so Quebec reenacted all of its laws to include Section 33 as a form of insulating politically. This is the federalism dimension of Section 33 evident immediately after the patriation enactment, right?
Mm-hmm.
And so the Parti Québécois enacts all of its laws with Section 33, all of Quebec's laws, including retroactively. And what happens is that one of the laws protecting Quebec's sign laws, French-only sign laws, expires. And that is challenged and found to be violating freedom of expression. And in the process, the court comments on the nature of the invocation of Section 33. It says that Section 33 was not meant to be used retroactively, that they found that the retroactive usage itself was unconstitutional as a usage, partly because of the way it's a anti-retroactivity is a principle of statutory interpretation, and also partly because of the wording of Section 33 saying it shall operate notwithstanding. Shall operate as it would, but for the shall is future oriented, so they say that means that it can't be used retroactively, and that's the holding in Ford about that's the holding in Ford that sets a limit on Section 33.
Mm-hmm.
So there's formal limits too. It's like it needs to be properly enacted as a law and
Yeah.
whatnot. It also needs to say the sections of the charter it applies to. It doesn't have to spell it all out. That was another argument saying, "Oh, every law must have, in order to avoid omnibus uses, every law must spell out the rights that it applies to directly." And they said, no, it doesn't need to go that far. It just needs to say the sections. The law that invokes Section 33 needs to say the sections of the charter it applies to. And it can't say sections that it doesn't apply to, right? So you can't target Section 3, right? And then it said, as a kind of summary of its view about how then limits on Section 33 work, it says there's procedural limits, but there cannot be limits. So there's limits in form, but not substance. That means that we're not going to go in and say, oh, you can't use it this way, you can't use it that way. We're going to say, you need to say the number, you need to not use it retroactively, but that's it. And that's the extent to which this court will intervene about Section 33. Now, that's a precedent, and I think that precedent holds pretty clearly that these arguments, and the Quebec courts held this too, that these arguments being made that all the courts should get back into business of even doing declarations, even if they don't apply, that goes against the Ford precedent. And I think that's right. I think that Ford, you can make clever arguments about why Ford doesn't apply to them, because you can say things like, well, the Ford didn't address Section 33.2, which is where Weber looks to the text to justify the declarations theory, right? But Ford is pretty clear. It's pretty global in that statement, and I think that should guide the court going forward. I think in order to make declarations, I agree with my colleague Hoy Kong at UBC Vancouver about this point. I don't agree about his interpretation of what the court should say if it did overturn Ford, but he and I both think, in order to get something like these declaratory views, you should be overturning Ford directly. And I suspect that also adds some weight to the side, the justices who may be convinced that they shouldn't be getting in the business of making these declarations even, never mind Attorney General Fraser's ideas about more substantive limits. I mean, those are pretty substantive limits, right?
Yeah.
And and it would seem like substantive declarations that things that laws that enact Section 33 violate rights, that seems to be matters of substance, not form, right?
Yeah. Yeah, no, and it makes sense given the centrality of the notwithstanding clause in the enactment of the charter that questions about its proper application, the formal procedural ones, one would have to ensure that those are followed, but that the content is very much what it's all about, and so
Yeah.
should not be unduly restricted. So you alluded to the many invocations by Quebec, right away, right off the bat. But in recent years, we've seen other provinces adopt it more frequently. Ontario, and you earlier referenced Saskatchewan. What are the trends here, and what's behind it?
So you see several different periods of notwithstanding clause history. There's a period between the Meech Lake Accord and even up to 2018 where the clause is not used very much, especially not outside of Quebec. It's always used a little bit more in Quebec, and it's even used. And if you count renewals, it's used a lot more in Quebec because they're often just renewing things that they have it in, right? Including cases like they're renewing things like protecting um, basically pension rules that favor women in various ways that they would worry would be challenged under the charter, right? So in very progressive uses by Quebec, uh, and um, it's led some of my colleagues like Guillaume Rousseau at the University of Sherbrooke Faculty of Law to say that there's a kind of Quebec theory and understanding of the notwithstanding clause that's always included renewing it a lot and um, and and resisting judicial activism over the long haul that way. Um, but anyway, there's been different phases. The initial phase featured Quebec using it, despite Quebec not being one of the main advocates for it in the process that led to 1982. Right, Quebec doesn't sign on to the Constitution. The notwithstanding clause is not enough of a good deal. It's not a deal maker for Quebec, right?
Mm-hmm.
But then what you have is since around 2010, the invalidation rate, the rate at which the Supreme Court of Canada has been striking down provincial laws under the Charter, starts to climb. So my
Mm-hmm.
research with Professor Dave Snow of the University of Guelph, he's a MLI senior fellow too. We show that you can look this up. It's called notwithstanding centralism. We show that two things happen that lead to the uses of the notwithstanding clause more. One is that the provincial rate at which provincial laws are struck down by the Supreme Court starts to climb since 2010 and goes quite high in recent years. So what that means is that when the provinces enact a law and they're worried about charter implications, they're worried about lower courts invalidating it too, and they're pretty sure they're not going to win if it gets to the Supreme Court of Canada. And so they're incentivized to use Section 33 because they have very little confidence in winning on charter issues when their cases get to the Supreme Court, right? They also have lots of aggressive trial court cases, like you've heard the case about bike lanes, basically constitutionalizing not a right to bike lanes, but a right against having bike lanes taken out once they're put in, right? Which could have perverse consequences for bike lanes because if you constitutionally entrench bike lanes, people may be less willing to put bike lanes in, right? The bike lane advocates haven't thought about that very carefully, I don't think. But we have aggressive. That's most people would say that's a very aggressive activist use of judicial review, right? Even defenders be like, well, yeah, we want an activist judiciary, but it's hard to say that's not a very aggressive interpretation of Section 7 Charter rights to life, liberty, and security of person, right? And we have trial court cases like that also incentivizing provincial legislatures to do this. And then at the same time, you have wider fights between conservative, right of center controlled provincial governments and the Trudeau Liberals and now the Carney Liberals, but particularly the Trudeau Liberals after 2015. And so that fight features all kinds of constitutional fights where the Trudeau Liberals are trying to enact centralizing policies, particularly policies centralizing centralizing environmental policy that the Western provinces in particular see as intrusions on their constitutional jurisdiction over natural resources. And so we have these constitutional fights about that kind of involves a struggle between keeping power decentralized over some of this provincial jurisdiction and power centralized overall. And the charter fights start to become seen in that framework too.
Right.
To the point where Trudeau says at one point, when Quebec enacts another Section 33 law, that we're going to refer this to the Supreme Court of Canada to put limits on Section 33. And the premiers are responding. This is so before Carney, before this factum, we had this fight brewing where the federal Liberals were championing the charter, and trying to say that they champion the charter, and they champion and they are opposed to Section 33 as this thing that sets limits on the charter and their preferred vision of charter rights, right? But
Mm-hmm.
what really is going on there is that the courts are giving rights outcomes that the federal Liberals like, and they're giving rights outcomes that the provinces don't like, that they see that different provincial center right of governments who have different ideological kind of perspectives see as invading their provincial jurisdiction.
Mm-hmm.
So the fight was partly jurisdictional too. It wasn't just about the substance of the rights questions.
Yeah.
And now we see that in spades. It's like our theory couldn't be proved better by the Supreme Court, by the Supreme Court of Canada being asked to rule on this, and being asked the federal government directly arguing to set limits on Section 33. Right?
Mm-hmm.
I mean, the Section 33 empowers the federal government too. Why do they want to limit their own power? Well, it's because they see the court as an ally in some of these centralizing, and as a centralizing ally, imposing national rights standards on sub-state, on the provinces,
Mm-hmm.
when the provinces get out of line and disagree with the rights outcomes that the federal government prefers.
Mm-hmm. Yeah, no, I can see that. There's certainly been an uptick in these instances of striking down and judicial activism, which would speak to the content side. But yeah, now you see many provinces who are not perhaps so the governments anyway, so ideologically opposed to some of the content of the decisions to take issue from a jurisdictional perspective. So this is this is just icing on the cake of a long simmering set of issues that we're going to see resolved, or perhaps not resolved, in a few months' time. Um, I want to ask you, Geoff, on hot button areas where this is in play: criminal sentencing, education policy, equality rights. Courts have developed, kind of expansive tests that are, I would say, somewhat vague, which gives them a lot of leeway to interpret and decide things as they like. Um, and that's where we're seeing a lot of the content-based concerns arise. I think it's fair to say, but I welcome your comment. How should Section 33 interact with those issues in particular?
Well, it depends on the issue you're asking me about. But basically, Section 33 allows for the legislature to have a say about those kinds of rights questions, and until it expires. Now, what I think is that once it expires, it doesn't just mean that the legislature's view should just be struck down right away. I think the courts need to take into consideration what was enacted, and calibrate their rights jurisprudence to better understand and kind of track the different points of view and perspectives at play in some of these issues. Um, and part of that is that I think there needs to be a bit more recognition on the part of the judiciary that their own approach to these issues can cut down on the perspectives available, and informing the kind of conversation that they're having. Um, and so, and they can actually have a negative impact on different kinds of public policy conversations, because people can use the courts as a kind of way to shut the conversation off. They can say, well, the courts held that bike lanes are constitutional, so no more discussion about that. Or like, you're opposed to the rights, you're opposed to the charter, rather than talking like, okay, why? What rights are at stake here? Why do we care about those rights questions? Are there different views about those rights questions? Do we care about other things other than those rights questions? Those kinds of concerns often do come into the courtroom, but they're often forced into forms they may not take as free and as many diverse forms of argument, because they're supposed to be focusing on what the courts have said before. They're shaped by that. They're shaped by what the text might say about these rights issues, right? And so the court may be sometimes doing us a favor in some of these rights conversations by enlivening it or introducing evidence and whatnot that may be helpful. But it can also distort things, right? Like if the evidence is wrong, or the court cherry picks what it likes in the evidence in the case,
Mm-hmm.
or the court cherry picks an interpretation of the text, or reads in controversial moral principles into the Constitution, it can delegitimate other sources of evidence. It can delegitimate other moral perspectives, right?
Mm-hmm.
And that's a problem. And so it can. I think the Leckie and Weber, not the Leckie and Weber, the Leckie and Mendelsohn view of the ability of declarations uh, about laws invoking Section 33 to better inform the conversation, I think it just completely does not underestimates the extent to which courts can misinform the conversation. They can warp our conversations about these things. They can even short circuit them insofar as you'll see pure political actors saying, "Well, it violates the charter," and then they don't have any reason other than that. They don't.
Mm-hmm.
They probably haven't even read the case where that comes from, right?
Yeah. Okay. Well, you've given us a very good sense of what is at stake here, and the history, the development of our philosophies and practices of judicial interpretation here in Canada. It's something at MLI we have been focused on more so in the past few years through the work of our legal fellows, such as yourself and others. And it is quite timely as we have two new legal projects that we're launching very soon. One, the Landmark Cases Council, which will take a look at major Supreme Court decisions and look at their policy impact, their impact on the development of the law, and kind of reassess them and what we might do about them going forward. And then another, Judicial Foundations Project, which is more squarely focused on delineating the proper role for courts, legislatures, and executive, and the power that they ought to employ that's consistent with our legal traditions, our understanding of the importance of Parliament and the kind of rule of law, black letter law. You're involved with both, Geoff. I'd just like to hear from you. What you think about the importance of tackling these issues through kind of a public policy lens, and what you're going to be doing with these projects.
Well, on the landmark cases one, I'm very excited to be writing about the Oakes case, which is sort of a very foundational way in which most charter rights questions end up asking about how to understand the limitations on rights. And Oakes was a sort of landmark case about how to understand that question. And I think it's particularly important because it sort of filters into all of the other parts of charter, right, about how the courts then approach rights. I actually agree with Professor Weber on this issue, which although we disagree about Section 33, we quite agree about Section 1, where we think that Section 1's reasonable limits clause has been understood to justify infringements of rights. And I think that's the wrong way of putting it. That way and Weber thinks the same, that justifying infringements on rights puts the judiciary squarely in the seat of talking about policies and ends, utilitarian kind of analysis justifying the infringement of rights, which seems completely like judicial characters doesn't seem very well suited for that kind of inquiry. However, might think it's disciplined by the structure of the test developed in Oakes. So I'll be writing about that and drawing a lot on Professor Weber's work and doing it, and with some other talented colleagues that are on the team on that project too. And then the judicial. So I'm very excited about that. I think it's very timely, and I think that the next few years are going to offer a lot of opportunity to talk about the appropriateness of the proper relationship between the judicial role and the legislative role and the executive's role. And this Landmark Cases project will help with that endeavor, and the Foundations project will also be able to delve into some first principles about how to understand the relationship between these institutions, and also draw on policy work and political science work about those big questions.
Very good, Geoff. Thank you. Yeah, good mix of lawyers and political science voices to balance out the perspectives in these two projects. Please look out for those as they are introduced in the coming weeks and months. Geoff, I want to thank you for your time. We'll have to come back again and see where you landed in terms of your forecast. It was very courageous of you to be so bold. And
see if I lose all my chips.
yeah, we'll have to see.
Yeah.
But anyway, I'm Peter Copeland for the Macdonald-Laurier Institute. Thank you for joining us.
Thank you so much.